their union representative confidential, which is essential to fostering trust and ensuring effective representation. This bill does not apply to criminal investigations. It merely codifies existing California Public Employment Relations Board decisions that prohibit public employers from coercing union representatives. AB 340 encourages employees to communicate fully and frankly with their union representatives about matters within the scope of representation. With me today is Randy Perry with PORAC and David Mastagni, legal counsel with PORAC.
All right, Mr. Perry. Oh, Mr. Mastagni.
Chairman Umberg, members, thank you for the opportunity to speak on behalf of PORAC today in support of AB 340. My name is David Mastagni. As a labor attorney with over 25 years experience representing public employees and unions, I understand the importance of this bill. It codifies important PERB precedent, making it an unfair practice for public employers to compel disclosure of confidential communications relating to union representation. I'd like to address the opposition's misrepresentations. School administrators claim this bill hinders AB 218 investigations. That's not true. That bill merely extends time for childhood sexual assault victims to sue. It doesn't mandate investigation tactics or interviews. Schools can question any witness about firsthand knowledge of an assault, ensuring that they can conduct robust investigations. This bill only protects representation-related communications, like pre-interview advice, which lacks evidentiary value. Compelling union reps to disclose this type of secondhand information unlawfully commandeers the union representative to impeach their own members, thus trilling trust in the union. I would invite the opposition to identify any legitimate line of questioning prohibited by this bill or any PERB case permitting inquiries into representational communications. None exist. AB 340 fosters trust and fairness for workers. We respectfully request your support.
Thank you. Mr. Perry.
It's late, what he said.
All right. Others who are in support of AB 340, please approach.
Navneet Purrier on behalf of the California School Employees Association in support.
Thank you.
Mr. Chair, Senators, Kobe Pizzotti on behalf of the California Association of Psychiatric Technicians in support.
Thank you.
Good evening, Beth Monowski with SEIU California in support.
Thank you.
Mari Lopez, California Nurses Association in support.
Thank you.
Eric Paredes with the California Faculty Association in strong support, proud co-sponsor. Thank you.
Thank you. All right, anyone else in support, please approach. Seeing no one else approaching, let's turn to the opposition. If you're opposed to AB 340, please approach the microphone or come sit at the table. The floor is yours. Whoever would like to go first, go ahead.
Good evening, Mr. Chair and members. My name is Aaron Avery with the California Special Districts Association, respectfully opposed to AB 340, a bill that would mirror an evidentiary privilege while hindering important employee workplace investigations. We respectfully urge a no vote on this bill today for three primary reasons. First, although the bill states that it is intended to be consistent with the William S. Hart Union School District PERB decision, the bill's restrictions go well beyond that decision. That decision engaged in a circumstantial analysis to determine whether or not employer questioning was prohibited while weighing the employees and the employer's interests. AB 340 goes beyond that, foregoing any circumstantial analysis or weighing of interests. It categorically prohibits certain lines of questioning, and the need for this change has not been established. There is no evidence that PERB is not appropriately protecting employee interests in this regard. Second, by preventing employer questioning of certain individuals with potentially relevant information, the bill still will function like an evidentiary privilege in some contexts. For example, in two-party litigation between an employer and an employee, if an employer is prohibited by this bill from requesting that a court compel testimony that testimony will be effectively off limits, just like a privilege. However, unlike privileges in professional contexts such as attorney-client or physician-patient, this bill lacks guardrails. There is no third-party regulator like the California State Bar or the California Medical Board, and there are no provisions for addressing conflicts of interest, which are acute in a workplace where an employee agent is representing the collective bargaining unit as a whole. Third, regardless of whether the bill's provisions are characterized as a privilege or not, it will interfere with employer investigations where potentially relevant information may be shared with an employee representative. Finally, the bill's exclusion of criminal investigations and certain police matters we believe to be exceptionally narrow, leaving many non-criminal, HR, and administrative matters left.
You want us to vote no?
Not covered. Thank you.
All right, thank you. All right.
Dorothy Johnson with the Association of California School Administrators. Also want you to vote no, please. We are in respectful opposition, joking aside, and we appreciate the committee analysis for pointing out some really important distinctions that the sponsors raise. The committee analysis points out that this is in fact an expansion of HART and does create additional limitations and restrictions on employers' rights to investigate. And it is not just the shop steward, it is also of the employee on both sides of that communication. So I think that's another important distinction. The proponents brought up AB 218. That is a nice way to say childhood sexual assault, which schools do have a duty to investigate. So while this bill does not change AB 218, it does speak directly to the heart of the need to prevent and remove bad actors from the school setting. And finally, we are deeply concerned that the way this bill is drafted, employers may not even know that they are violating this new rule because it is only the employee and the representative who have full knowledge of what they are considering to be confidential and in the scope of the representation. So we do respectfully request your no vote. I'd also like the urban counties of California on their behalf to be associated with our opposition. Thank you.
Thank you very much. Others who oppose, please approach, give us your name and your affiliation and your position.
Ethan Nagler on behalf of the California Association of Recreation and Park Districts, respectfully opposed.
David Krieger for the California Hospital Association, also in opposition.
Good evening, Johnny Pena with the League of California Cities in respectful opposition.
John Moffett on behalf of the Orange County Fire Authority in opposition.
Good evening, Eric Blair on behalf of the California State Association of Counties, the California Association of Joint Powers Authorities, the Association of California Healthcare Districts, and the California School Boards Association in respectful opposition. Thank you.
Lee Kamrick with the Rural County Representatives of California in opposition.
Jason Schmelter on behalf of PRISM in respectful opposition.
Ashley Hoffman on behalf of the California Chamber of Commerce in opposition.
All righty. Thank you very much. Bring it back to committee. Questions, comments? Saying yes, Senator Allen first. All right, Senator Caballero first. Okay, one of you first.
Reverse alphabetical order.
Let me ask a question. How this is a prohibition. So how does the employer know whether the information that's been communicated to the shop steward or the union rep, how do they know that that is, that they can't get that information? In other words, is there a penalty for asking the question just to be able to figure out if it fits within the parameters of the bill?
I'd like to have David answer.
No, Senator. There's two answers to your question. The first is this bill is not prohibiting questions regarding any union communications. It's a narrower subset, not an expansion of HART. It only deals with confidential communications in connection with representation, which in 99% of the circumstances should be very obvious. It would be questions like, what did your representative tell you? What did your member tell you while you were preparing for the interview? Certainly, if there's a question that accidentally intrudes upon those kind of communications, then it's incumbent on the union shop steward or the member to assert that that information is confidential, and potential liability within PERB, not financial, would only attach if, in the face of that information that it's confidential, they ordered the employee or the union shop steward to disclose that information, which they would typically do because it would be under threat of termination, and then they would have to go to PERB to seek redress after the fact.
I appreciate that, because that's a very specific sequence that makes it easy to know if you're in violation or not, and I appreciate that there's no penalty for asking the question, because it's the employer's duty to get details about whether conduct was appropriate or not. But if it's up to the employee and the union to exert the privilege, or actually, let me reframe that, because it's not a privilege, the protection, then I'm satisfied with that. Thank you very much.
Next,
Yeah, I mean, it's along those lines. I'm glad to hear your answer. I guess, so if the employee or the union rep at that point assert the protection, is it just what happens at that point? It's an assumed.
Well, typically, having sat in more than a few representations of members being subject to fact-finding or disciplinary investigations, even as an attorney, I'll assert an objection, and if the employer orders the employee to answer the question, I've made my objection on the record, and then we assess after the fact. I'm not going to instruct somebody not to answer a question and potentially get fired for insubordination if I'm incorrect, and it would play out the same way. If there was a dispute over a violation, PERB would have jurisdiction to resolve that, and PERB would look at the factors. I would also note that the statute, or the bill rather, incorporates and is consistent with HART. It's in the second paragraph of the bill, and so in HART, no PERB cases upheld employer interrogations into those kind of compelled questions. They really look at the facts and circumstances to determine if it is a confidential communication, and I would think that's how it would play out if there was litigation.
Okay. Yeah, I mean, obviously, the opposition continues to raise this concern about just the asking of the question. I get your point. We spoke earlier, and you said, nobody's going to take a case to PERB just because of a question asked, but I wonder if the bill does proceed out today, and I think I'm in line with the kind of the general goals of the bill. But assuming the bill passes out today, I wonder if you could spend a little time just to make sure that's clarified and really locked down, because that would seem to be. I understand 9 times out of 10, no one would bring that kind of case, but I certainly don't want this to be used as an excuse to haul, as part of a broader dispute, for example, to haul an agency in front of PERB for frivolous reasons.
That's certainly not our intent. It's quite the opposite, is to provide clear guidelines so that the employers know what's permissible and the unions and the employees know what's permissible, and you can avoid having those kind of confrontations. PERB litigation is costly and time-consuming, and nobody is interested in unnecessarily engaging in PERB litigation.
Thank you. Senator Wahab.
All right, so I just want some clarifying information. So I just want to understand that obviously we want to protect employees and, making sure that they have the ability to fully communicate with whoever represents them. But the question I have is that, for example, and you guys mentioned a number of different organizations and much more in the analysis. If there are individuals in law enforcement in particular that are communicating with each other in a way that is unbefitting of a law enforcement officer, and they are sharing information that is incredibly viable and important to a particular case or even their conduct or whatever the case may be, how is that handled?
I appreciate the question. That's frankly not a concern. First, the exclusion or actually incorporation of the Peace Officers Bill of Rights prohibition against a representative being a precipient witness or involved in the underlying circumstances being investigated would completely preclude a peace officer from trying to assert this bill should it become law. Secondarily, this bill is narrow. It's only renders confidential communications made in the course of representation. So that means there has to be an expectation of confidentiality between the member and the representative, and it has to be in conjunction with a disciplinary investigation, a whistleblowing complaint, filing a grievance, things of that nature. If there's like loose or inappropriate comments or conduct, none of that would fit within the ambit of this statute, and there's nothing in this statute, even if there was some kind of representational relationship, that would preclude an employer from interrogating either the union representative or the member regarding anything that they saw, did, observed. It's really limited in scope to when they're sitting alone in a room preparing, like Weingarten, for that's considered the pre-interview consultation. It's that information that the employer is not able to question about. In other words, they can't go into a representative that's totally unrelated and say, hey, we don't believe your member on what they just told us in the fact finding. We want to commandeer you to do the investigation for us and disclose everything that they said to you when you were alone in the room with them and they thought that you had confidentiality, and in a sense make the union representative an impeachment witness against their own member. But your circumstances, this bill doesn't even come into play.
Okay. And then what if they did share a significant amount of additional information that could potentially be utilized in any way? It's lawsuits in court cases that it has to be revealed?
If it's firsthand information, it's not covered by this bill at all. It's only communications in preparation for or in conjunction with union representation. So anything else, and also to the second part of your question, doesn't apply at all in a criminal proceeding. And in a civil proceeding, the employer is almost never going to be the plaintiff. Like on 218, it's going to be a victim suing whoever the abuser was and possibly the school district in that circumstance. They can compel, this has no application to them because they're not the employer. So if the court will allow it, they could compel whatever communications that a court will allow.
All right, thank you.
Senator DeRosso.
Thank you. I just, this could be very simple, right? An employee wants a union representative and want to be able to talk to them about the issue, a potential grievance, and you want to be able to trust that you're not going to go to the boss and tell the boss what they just told you. I mean, it's a pretty simple thing, it's not so complicated. Anybody would want to be able to trust their union representative with whatever they talked about. And you give protections on the issue of will not supersede laws relating to public safety officers or criminal investigations. I mean, that's off the table. This is in the case of representation between the employee and the union rep.
That's exactly right. In fact, the Merced case in Perb, that's the other seminal case, it involved interrogating a union president about the identity of a whistleblower who went to the union to advocate on their behalf about unsafe working conditions.
Thank you.
All righty, thank you. Other questions or comments? Senator Stern?
bill.
Oh, Senator Stern has moved the bill. All right, thank you very much. All right, I think the bill has been moved. Would you like to close?
Senator DeRosso spoke my closing already.
Oh, very good. All right, thank you. Ms. Mustagni, please give my best to your family. All right, with that, Madam Committee Assistant, please call the roll.
This is file item 74, AB 340. The motion is due pass to Senate Appropriations. Umberg?
Aye.
Umberg, aye. Nilo? Nilo, no. Allen? Allen, aye. Artegin? Artegin, aye. Ashby? Caballero? Caballero, aye. Durasso? Durasso, aye. Laird? Laird, aye. Stern. Stern, aye. Valladares. Wahab. Wahab, aye. Weber Pearson. Weiner. Weiner, aye. 9 to 1.